Ladies and gentlemen, welcome back. This is Kathy. I wanted to give you some breaking news. I just published a note on the community, but I wanted to get up here too. There was an order that was rendered by Judge Stephen J. Hippler regarding the recent defense motions to strike the death penalty, of which there was oral argument just a couple of weeks ago in the case. Each and every motion has been denied. The judge categorically, in a very long order, it is 35 pages of a memorandum of law and his decision where he went through all of the bases that the defense raised, such as the HAC, the heinous, atrocious, and cruel, the multiple victims, and the one motion that I thought had possibility. This was on a due process issue with the motion for the order requiring the state to provide notice of non-statutory aggregators and prove beyond a reasonable doubt. In this motion, this is page 27, Judge Hippler says that the defendant moves for an order requiring the state to, number one, provide notice of any non-statutory aggravating factors or circumstances it intends to prove at the sentencing phase, and number two, provide any such non-statutory fact or circumstances beyond a reasonable doubt to the unanimous satisfaction of the jury before any juror may consider any aggregating fact or circumstances in terms of a reason to support the death penalty. This is on page 27. For the next couple of pages, the court goes into a very lengthy reasoning why this motion is being denied, satisfied that the state has provided enough information, what the defense is asking for here regarding the non-statutory, the aggravators that are not listed by the statute, is not required under Idaho law. So that is one of the motions that have been denied. But again, all of the motions have been denied in this very lengthy memorandum and order that was entered by His Honor Stephen J. Hippler, coming very soon after the oral argument on the motions that was entertained by the court just a couple of weeks ago. So what does this tell us? This does not mean that Mr. Kohberger is guilty of anything. This is only the process that must happen at this time during the proceeding, that if the state of Idaho proves its case beyond a reasonable doubt and they go into the sentencing phase, that the death penalty would be available, could be available as a possible sentence. The defense was trying to get them knocked out. This has unfortunately for the defense been denied, and I will come back to you and go over the reasons for all of the motions, why Judge Hippler denied them. So now we are awaiting the responses to the multiple motions that the defense filed. If they are successful, let's just say on the Franks motion, there may not be a trial if there is enough evidence that is thrown out, if the defense is able to prove that Mr. Kohberger's Fourth Amendment privileges were violated. So we await the state of Idaho's responses. They are due in the beginning of December. The reply by the defense is due thereafter, also in December. And then the oral argument, just like we saw on the death penalty motions, will happen January 23rd going into the 24th, with the exception of the Franks hearing. If the Franks hearing is granted, that may happen at a different day or time. This will now conclude this episode of our YouTube channel on the Idaho 4 case. Thank you for joining us here today.